Good morning or good afternoon. I apologize. It is after 12. The meeting will now come to order. Welcome to this meeting of the Charlotte Unified Development Board of Adjustment on Tuesday, January 27th, 2026. My name is Deborah Dryden and I'm chair of the board. Would the board members please go around and state their name for the record? Marshall?
Marshall Williamson.
Kevin Shea.
Push the green button. There you go.
Janice Shirley.
Also present, or will be shortly, Solomon Fortune, our zoning administrator, John Kinley, senior project manager, Crystal Monsegur, our planner, Kamisha Lampley, the clerk to the board, Teree Hegler Gray, our senior assistant city attorney and advisor to the planning staff, Paige Inman, assistant city attorney advisor to the board, and Elizabeth Majors, our Veritex court reporter. Each of today's hearings is a quasi-judicial evidentiary hearing. That means it is like a court hearing. State law sets specific procedures and rules concerning how this board must make its decision. These rules are different from other types of land use decisions like rezoning cases. The board's discretion is limited. The board must base its decision upon competent, relevant, and substantial evidence in the record. A quasi-judicial decision is not a popularity contest. It is a decision constrained by the standards in the ordinance and based on the facts presented. If you will be speaking as a witness, please focus on the facts and the ordinance standards, not personal preferences or opinion. General witness testimony is limited to facts. For certain topics, this board does need to hear the opinion testimony from expert witnesses. These topics include projections about impacts or property values and projections about impacts of increased traffic. Individuals providing expert opinion must be qualified as experts and provide the factual evidence upon which they base their expert opinion. While hearsay evidence is not specifically excluded, it is only given limited weight. Parties with standing have rights to participate fully. Parties may present evidence, call witnesses, and make legal arguments. Parties are limited to the applicant, the city, and the individuals who can show they will suffer specific damages. Other individuals may provide testimony as witnesses when recognized by the board. Witnesses must swear or affirm their testimony. Any individual wishing to speak as a witness today was required to sign up. If you haven't done so, please do so now. The parties to each case are entitled to an impartial decision maker. A board member may not participate in a hearing if they have a fixed opinion about the matter, a financial interest in the outcome of the matter, or a close familial, business, or associational relationship with an affected person. The parties in each case also have a right for any ex parte communication to be disclosed. Ex parte communication is any communication about the case outside of the hearing. That may include site visits as well as conversations, with parties or the general public. At the start of each case, any potential conflict of interest or ex parte communication should be disclosed by a board member, if applicable. These matters may also be raised by an affected party. Today's meeting will follow the order printed on the agenda. The order of the regular agenda will be as follows. All parties who plan to give testimony must be sworn in. A city staff member will present a summary of the case. The board may question the staff member, and then the applicant may question the staff member. So pardon me 1 second. Let me get a sip of water. Thank you. The applicant presents their testimony for the case. Any sworn witnesses provide testimony. The board and city staff may question the applicant and their witnesses. Other parties wishing to speak for or against a case will be given reasonable time to present sworn testimonies. The staff and the applicant will be given an opportunity for rebuttal. After each case, the board will review each case and render a decision. This is usually done in closed deliberations after hearing each case. The chairperson calls for a motion and a second to approve or deny the variance or appeal. You may remain present during the deliberations, or you may call the zoning office after the session to receive the decision of the board. If you wish to receive a written copy of the decision letter, please indicate so on the sign-in sheet. All exhibits must remain with the board. If your case is not appealed to Superior Court after 30 days, you may pick them up or they will be destroyed. Appeal from this board is to the Mecklenburg County Superior Court. You have 30 days from the date of the board's written decision in which to appeal in accordance with NCGS 160D-405D. All right, okay, I'd like to swear in our city people, please. So if you're going to respond today, if you would. Okay. Do you solemnly swear or affirm that the evidence you shall give to the board in this action shall be the truth, the whole truth, and nothing but the truth? Thank you very much. We now open the evidentiary hearing for variance 2025-00047. The property is located at 3920 Tryon Park Road. Does any board member have a conflict of interest or potential conflict or any ex parte communication they need to disclose? Okay, staff presentation.
All right.
Thank you very much.
John, before you get, we just need to put on the record for the applicant to let them know that we only have 4 members of the board and want to see if the applicant wants to proceed.
Okay. Amy Ellison and Land Design. Okay, all right. Well, we only have 4 board members today, so how do you want to proceed? Do you want to delay this again till we have 5, or do you want to go on with it? Okay, all right. Thank you. The applicant has agreed to continue.
And Sean, will you just say your name?
State and spell it for the court reporter. Sorry.
Sean Tooley, S-H-A-U-N.
Sean Tooley, SHAUNTOOLEY.
Thanks, Sean.
Thank you, Sean.
All
Can we
right.
clarify that when you said continue, that means proceed and not, okay, thank you.
Okay,
So this, the first case we have today, it's a variance from the legacy ordinance, section 9.8506 letter B, requesting to waive the screening requirement of section 12.3032. And if you look at the findings sheet that you have, basically section 9.85062B says that screening is required per section 12.303 when you're in the mixed use development zoning district. And in section 12.303, it says that utility structures there in 1C, utility structures associated with the building shall be basically screened, and the screening should be planted area that's at least 5 feet wide. Or if only a fence or wall is used, then the area devoted to the screen only be wide enough to accommodate a wall fence to allow maintenance. So that's the provisions they're asking basically to be waived here for some transformers, the Duke Energy transformers that were installed on the site. And we'll get into the details here. It's the vicinity map in Exhibit 1. This is up near the University City Boulevard, the University Topgolf area. It's actually kind of adjacent to the University City Topgolf, if you're familiar where that's at. The property is zoned MUD CD. It was rezoned by rezoning petition 2021-112, and that conditional zoning plan didn't specify any specific conditions related to screening. So the screening requirements are based on the base ordinance standards, which is why you all have authority to potentially grant a variance to that, because it's not a condition of the conditional plan. Exhibit 3 is the zoning map, again, just showing the MUD CD zoning of the property. Exhibit 4 is a bird eye imagery, and this building, again, it's constructed, and the areas we're talking about are the transform boxes located here and here. the variance request is to waive the screening requirement of section 12.303(2). The applicants have offered and agreed to a condition that the landscape screening that was shown on the approved plans would be provided. They're just not going to be provided in the same location that the approved plans were shown, because there's not space between those transformer boxes and the sidewalk. And that is shown here in this applicant's exhibit, variance exhibit, which is government exhibit number 6. Again, the utility boxes are here, and they're pretty much right up on the sidewalk. You can see and kind of see in this image here that there's just a little bit of rock between the sidewalk and the transformer boxes there. And then here, there is a little bit of grass, but not enough room to install any sort of a screen wall or landscape plantings.
So John, how did this come up?
So
If it was,
So the approved plans show the screening around the utility structures compliant with the ordinance standards. The construction of the site, it was substantially completed at the time that Duke came out to install the transformers. And Duke installed the transformers in compliance with their requirements, which has a certain standard for clearances from buildings and doors and windows, and a certain amount of space in proximity to sidewalks for access and maintenance. So the building was pretty much already built. Things were already installed in place in terms of site improvements, sidewalks, and that sort of thing. And then Duke came along to install the transformer locations. And that's how they ended up being close to the sidewalk, to the point where they didn't comply. Basically, Duke didn't follow the approved landscape plans. And this was caught whenever the inspector went out to do the final, CO clearances to make sure all the plantings were installed.
so Solomon, are you guys working on this so that these developers work more closely with Duke so we don't have these problems? Because this is not the first one of these that's come up in our meetings.
So I want to be careful. I don't necessarily want to put this on the developer. We are working with Duke, because I think what happens is the design team, the designer shows Duke something, and then Duke, as I feel that Duke goes out there and their install crew does something different, because again, they have different requirements that they have to meet, obviously because it's electricity, safety, things like that. And so we are working with Duke to say, how can we work on this and avoid this? Because again,
Mitigate this.
what happens is our reviewers, they see it in compliance with the ordinance, they sign off, and then it gets built in the field. And like as John has mentioned, now the applicant is trying to get a CO, and Duke has put the transformer where now we can't get any trees or anything for screening.
You have a single contract that do?
We have several. So we are working with a group of them. So it is, to answer your guys' question, it is their residential, commercial, I forget what her name is. She is like the head of the interlocal. She deals with government. So we meet probably about once a month. We've got to get that back on schedule, but we were meeting last year every month to talk about issues that Duke is running into, and kind of how we can work and avoid problems on our end, avoid problems on their end, and then also point out for as developments come in, especially as we're urbanizing in these urban areas, and getting Duke notified so that they can reach out to the applicant prior to getting this far down the road.
Right, because
Is Andrew Graff part of that? From Duke?
I would need to follow up with you, because I think he might be, but like I said, there was probably 10 or 12 people, and we got someone from, I forget what to say, from like Piedmont Natural Gas. So there's a whole bunch of us meeting.
yeah, I mean, I would like to see some communication before the building is like 2/3 finished, and then all of a sudden it's like, oh, wait, this doesn't work. Because I'm looking, so you're in this bottom picture, they're putting the plantings across the sidewalk from, okay,
Yes, in the planting strip.
because I understand there's no room between the unit and the sidewalk. Okay. Sorry, John, you may continue.
Okay, thanks you. So again, just kind of as you just pointed out, the condition that the applicants have agreed and offered to is to provide the same number of plantings that were shown on the approved plan, but in just different locations. So for the northern set of transformers, they'd be to the side. For that southern set of transformers would be to the side, and then also they have some space to put in some additional shrubs in the planting strip there, and that's what's shown in this bottom image. My understanding is believe that those plantings have already been installed, and I think Urban Forestry maybe has taken a look at them or will be shortly. Next slide, Exhibit 7 is the standards for granted a variance. All 4 standards have to be met in order to grant a variance. And I'll give you all a minute or two to look over the findings of facts and conclusions of law before I dive into those.
Right, I see that it says on here that the applicant has agreed to the condition of the variance that landscape screening as generally depicted on the plans will be provided. Is that anywhere in the finding of facts, or is that just a statement?
Number 18.
18, okay, thank you. All right. Okay,
And for future reference, generally we try to put the condition, if there's a condition that they've agreed to, we generally try to put it down towards the end of the findings of facts
Right,
where-
that-
under the spirit and intent section.
okay, I just wanted to be sure. Okay. Thank you, you may continue, John.
All right, unnecessary hardship would result from the strict application of the ordinance. Again, the construction of the site was substantially completed when these transformers were installed. Compliance with the strict application of the ordinance would result in requiring significant changes to the site's construction, including the way that electrical service was ran throughout the site. The development's layout and Duke's required clearances from the windows and doors and required location related to sidewalks restrict the amount of area that's available to put in the required screening. And Duke installed the subject transformers per their requirements and not per the approved landscape plans. Hardship results from conditions that are peculiar to the property. Because the Duke requirements applied to the property after the approval of the plans and after the construction commenced, it was nearly completed at the property. Duke installed those transformers, including to their required clearances from buildings, windows, doors, and proximity to sidewalks, and not per the approved plans, and the transformers were placed too close to the sidewalk to install to be able to, such that there's not room to plant the required plantings or provide a screen wall. Transformers and the site's electrical service would have to be relocated to meet those screening requirements. Hardship does not result from actions taken by the applicant or the property owner. The applicant relied on the approved plans when they constructed their site, and Duke installed these transformers in locations per their clearance requirements and not according to the approved plans. And the requested variance is consistent with the spirit, purpose, and intent of the ordinance, in that public safety is secured and substantial justice is achieved. The requested variance would allow reasonable accommodation for the applicant to comply with the Duke requirements while considering the property constraint. The requested variance is granted, it would not substantially detract from the character of the neighborhood. The adjacent property, basically across the street, is a parking lot used for vehicle inventory for Park Chevrolet. It's not a commercial or residential use, and the approval of a requested variances would permit the transformers to remain in its current location compliant with the Duke requirements that promote public safety and not harm the public. And the applicant has agreed to condition of the variance that landscape screening would, as generally depicted on the plans, would be provided, and it will not alter the essential character of the neighborhood. And that concludes, there's a picture of the sign on the property, and that concludes staff's presentation, and I'll take any questions.
I have a question. And I'm new at this, I'm just asking a question. So really, what Duke installed is really, it trumps whatever the plans are, right? So are we really following Duke doing what they're doing, and then the planner already has his plans out, right? Am I asking the right question? Or do
Yeah,
you
so
understand?
yeah, the developer, when they come to get their building permits, they go through plan review and approval, and they have a set of approved plans that show things like landscape screening and locations of the building, that sort of thing. And those plans will also show, where transformers will be located. Well, their plans showed the transformers being further back away from the sidewalk so that there was space to meet the screening requirements. But then in reality, what happened when construction was going on is Duke came out to install those transformers, and they have certain requirements they have to meet in terms of proximity to sidewalks to get maintenance to them. And they also have to be a certain distance away from any sort of entry doors into buildings. And so Duke placed them where they needed them to be. And I don't know if you would say that trumps the city's requirements, because the city still has a requirement to be met But there's a bit of a conflict between the ordinance requirement and Duke's requirements, and that's why there's been these continued conversations with Duke Energy to try to get the city and Duke on the same page so that we don't have this continue to come up.
So can they not meet before they start that? So everybody would be on one page, like before they even start putting their stuff in? Or they just go ahead and Duke just go ahead and install them. They're not looking at, you see what I'm saying? Everybody meet before they start installing anything.
So, to follow up with that, the answer to the question is, we do have some pilot programs that we are working with Duke to kind of address these issues. And then also, Mr. Shea, real quick, staff, someone gave it to me, Andrew Graff is part of our meeting. He's on that list. So here's the problem with Duke. Duke is a large entity, and they will tell you they will like to meet with people, and they try to, but ultimately think of it as, it's kind of like the federal, I kind of want to put it in simple terms. It's large conglomerate sends it out to their construction crews. Their construction crews go out in the field and say, hey, the designer says, hey, you got to meet this for the city. Well, the construction crew get out there and says, we can't build it this way. We're here today. We're putting this in. And then they drive off the site. And then the builder gets left with this. Our zoning inspector goes out there and says, this isn't meeting our city requirements.
Okay.
And now they're kind of in this, as I call it, this purgatory where they've got to figure out, hey, can I get it in or can I not? And ultimately, like you see in this condition, there's no way for them to put any screening in there. They can't even put a fence or anything to meet it. Because again, we as the city staff, we will try to work with the applicant to avoid the variance. But in this case, you see, they just have no option.
Okay.
So I got a question. The screening for those transformers is it an aesthetic screening or is it a safety screening? Do we want the screening so that people don't walk up and sit on the transformer and transformer blows up when they spill their drink on it or whatever? Or is it simply to make it look better?
It's based on the code, it would be more for the aesthetics and screening. So that way that in those environments that you they blend in and you don't see them, especially in urban areas, because again, you start to get larger transformers, unlike when you're in suburban areas, such as subdivisions. We don't make them screen it, but you kind of don't see them because they blend in with people's yards. But typically when you get
Would it be, in this sort of case, would it almost be better to ask him to screen the transformers, but then give him a variance on the width of that sidewalk? Because I'm sure you require that sidewalk to be, 8 feet, 7 feet, something like that. So could they taper the sidewalk back and then screen it? And maybe give him a sidewalk variance instead of a screening variance?
You could, but now think about, I've added I guess being realistic and trying to be friendly with the developer, he's now got to rip that sidewalk.
In the future, I'm just saying.
So I guess here's the problem. They think about it as when they're pouring those sidewalks, probably in that sequence of construction, the planning sure the sidewalk goes probably in before you get out there and you actually put that transformer in. So now I would have to have them come back and say, for example, I'm gonna roughly say that's probably about 8-foot sidewalk, and you between 6 and 8 are standard sidewalk, depending upon what their zone. And now you would have to have them pull that out and you see where that manhole is.
I'm just thinking about the next one, maybe it's easier to avoid the problem if you shrink the sidewalk sometimes.
Mr. Williamson, too, if you look in section 12.303, it kind of hints a little bit at the intent of the screening requirements. It says that the area may contain any type of screening material sufficient to separate visually the land uses. So the idea is that visual kind of separation.
Okay.
Okay. All right, thank you. John, anything else? All right. Do I have a motion to approve? Board,
Make a motion to approve with condition.
thank you, Mr. Shea. A motion to approve with condition. Do I hear a second?
Second.
Thank you, Mr. Williamson. Ms. Shirley? I'm sorry, yes?
Yes.
Okay, Mr. Shea?
Shay, yes.
Williamson?
Williamson, yes.
Dryden, yes. So the variance is approved. Thank you. Thank you, Mr. Tooley, for being here today. All right, let's move on. We are now going to do, oh,
Funny fact.
no, been a long time. Sorry, it's been October, so or November. All right, yeah, approve the conclusion of the law, please. All right, do I have a motion to approve
Finding fact.
finding of facts and conclusions of law?
Motion to approve the findings of fact in
Shay second.
Shay, second. All right, so we are approving the finding of facts and conclusions of law with a condition. Ms. Shirley? Yes.
Yes.
All right, Mr. Williamson,
Williamson, yes.
Mr. Shay,
Shay, yes.
Dryden, yes. Thank you very much. Okay. All right, moving on to variance number 2025-00048 for a property located at 400 South Trine Street.
Property LLC is the property owner, and the property located at 400 South Carolina Street. And is requesting a variance from the UDO Article 12.3H to allow each facade to consist of material or building facade material called acrylic panelized facade system as a surface finish material in excess of 25%.
All right, before you continue, can we ask the representatives if they are agreeable to the 4-member board, or do you want a 5-member board?
Colin Brown.
Okay, so say your name again for the court reporter.
Colin Brown, Collin Brown from Alexander Ricks on behalf of the
Okay, and
petitioner.
you agree to have the decision made by the 4-member board?
Yes, ma'am.
Okay, thank you very much. All right, thank you, John. You may continue.
Okay, this is a vicinity map. This is in Uptown at the corner of South Tryon Street and East Martin Luther King Boulevard. Exhibit 2 is the zoning map. It is zoned to UC, which is the Uptown Core zoning district. This is the Exhibit 3 aerial close-up, and this is an existing building that you see here on the site with a parking deck kind of associated and attached to it at the back. And Exhibit 4 is a bird's eye image, and you can just kind of get a better view of the building that you see there with the long vertical windows running down the length of the building. And the variance request, again, is to Article 12.3H to allow each facade to consist of acrylic panelized facade system as a surface finish material in excess of 25%. So in the UDO, there's a section that deals with building materials in Section H for this zoning district and UC zoning. And it says the following building materials are limited to 25% of each facade along a frontage. And they can also be used as component construction when not a surface finish material without limitation. They don't apply to multifamily or attached buildings. But basically any commercial office type building is subject to the requirements of that limitation of building materials, and it includes those listed in 1 through 5 on the screen. And basically the panelized acrylic panelized facade system we would consider to be the same as exterior installation finishing system, or EFIS, which is number 2 on the list, and it's limited again to 25% for that facade facing frontages. This Exhibit 6 is just a survey of the property showing the existing building and the parking deck at the rear. Exhibit number 7 is some elevations that have been provided by the applicant. And so with this, basically what the applicants are proposing is to renovate and reuse and rehab this building. So it was formerly, I think, mostly Duke Energy offices, and Duke has since vacated when they constructed their new building. And so now this building, they're proposing to have a mix of uses in it. I believe it's going to be hotel and apartment uses, residential uses. And as part of that renovation project, they intend on changing the facade to be, instead of the long linear windows that are on there now, this panel system would allow them to add more windows throughout the building. And it would look similar to these elevations that are provided on the screen. So transparency increases because the number of windows are increasing beyond the size of the strip that's in there, but but this panel system is beyond the 25% of the facade that the ordinance allows. So they're asking basically to waive that 25% limit to be able to renovate this building with this facade material, to be able to get those additional windows and materials on the building. Exhibit number 8 is the variance standards. Again, all 4 of those need to be met. And I'll give you all a minute to look over the findings before I dive into those.
Is this material they're asking to put on the building durable? Is it I mean, it's an acceptable,
Yeah, it's an acceptable building facade material. It just would be limited under the strict application of our regulations.
and why did you set that regulation to start with?
I'll defer to Solomon on why
you
EFIS
know?
and those other building materials are limited.
I think going to the UDO, they just want to limit certain building materials, but obviously what happens is a building of this size for the reuse, they need to use that material and we are comfortable based on the elevations.
Okay.
John, these guys, this permit is active, right? The building permit. It's like 3 years old, isn't it? Something they've been working on this.
Yeah, we gave them a parking variance for.
There might be some other building permits out there because this is also the same site where they were working on the parking deck. I'm going to add some levels to the parking deck. So there may be multiple
yeah, I
permits sitting
remember
out there, but this is separate from whatever's going on back there. This is just for the office tower.
I'm just curious to know if this is covered. Because it said in the application that the building permit had already been pulled. I assume that was for this work.
We could try to verify.
Not sure if that makes sense or not. I'm just. It would change the permit if it were not.
Here it says, according to the applicant's variance application, existing facades have a transparency.
Yeah.
So, yeah.
We do, anytime there's a variance that gets approved for something that's already in progress or, has been recently approved, we'll either have folks do an RTAP or they'll have to, revise their plans that are in review to match what the variance approval is. So if you all do decide to approve this variance and whatever's approved doesn't match what they submitted when if there was a permit that was originally submitted, they would need to update it to match.
That was my question.
That's what I thought you were getting at.
Okay, you may continue.
All right. Unnecessary hardship would result from the strict application of the regulation. The UDO does not specifically define EFIS, nor does it define APS or the acrylic panelized facade system, and does not expressly prohibit APS as a building facade material. APS has been reviewed by the planning staff and the zoning administrator, and we determined that it falls under the EFIS category. So that's why we established that it would have that 25% limitation. And according to the applicant's variance application, APS is distinguishable from exterior insulation finishing systems or EFIS. APS is a versatile, durable system of acrylic panels that is prefabricated offsite. And APS allows for water drainage and drying behind the acrylic panels, unlike some of the moisture management concerns that are come with traditional EFIS material. So there is a bit of a difference, but they're similar enough to where staff felt like they belonged in the same category. Hardship results from conditions that are peculiar to the property. The existing structure was designed and built around 1974, and it doesn't meet the current building design standards. The property has frontage on South Tryon, Martin Luther King Jr. Boulevard and South Church Street. And the parking structure is located on the property that fronts South Church Street. The subject building on the property only fronts South Tryon Street and Martin Luther King Jr. Boulevard. And the site configuration of the property is such that only half of the facades are subject to the 25% building material standard. An approval of the variance would allow for a consistent building facade on the entirety of the building. All 4 sides, essentially. The hardship does not result from actions that were taken by the applicant or the property owner. The hardship results from the strict application of the regulations and ordinance and does not explicitly allow or this specific building material and is interpreted to fall under EFS. The hardship also results from the design of the existing building and the site layout and the act of purchasing property with the knowledge that circumstances exist that may justify the granting of variance are not, is not regarded as self-created hardship. The requested variance is consistent with the spirit, purpose, and intent of the regulations, and that public safety is secured and substantial justice is achieved. The existing structure constructed in 1974 is legally non-conforming as it relates to the transparency requirements. And according to the applicant's variance application, the existing facade has a transparency of approximately 17%. With the approved panel system and the approval of the variance, that transparency would increase to about 35%, which supports the UDO's focus on pedestrian-oriented development and transparency and intent for architectural harmony. And the applicant and staff have reviewed the proposal and found that a variance would be the only avenue for relief from the strict applications and regulations while allowing the proposed adaptive reuse of the structure. And the requested variance will not substantially detract from the character of Uptown, and it improves the transparency of the structure, benefiting the pedestrian environment of Uptown. And exhibit 11 is the sign on the property, and that concludes staff's presentation.
Okay.
How often are you seeing EPIS now? It's dying, isn't it? Such a,
Sir, it's very much alive.
is it still
Yes,
alive?
sir. Oh,
Yeah, if you're gonna speak, you need to come and,
Be sworn in.
or
So,
do we want to?
so we are still seeing it. It's just. So I wouldn't say it's out there. We're seeing it. So obviously what happens is it's just where the UDO, where it became for this building because we put a 25% limitation. That's right, but it's still, we're still seeing it used as a building material.
I would note that the APS system makes this building look dramatically better, so it would be in my favor for sure.
Any other questions or comments from the board? Okay, do I hear a motion to,
Just want to ask for the record if there's anyone that's opposed to the
oh,
variance.
is there anyone that's here opposed to the variance?
Just for the record.
Just for the record, I didn't, okay, hearing no one, thank you. Great, all right, do I hear a motion to approve this variance?
Motion to approve?
Thank you, Mr. Shea. Do I hear a second?
Williamson second.
Thank you, Mr. Williamson. All right, Mr. Williamson,
Yes.
Mr. Shea,
Yeah, yes.
Ms. Shirley,
Yeah.
and Dryden, yes. So the variance is approved. Now looking at the finding of facts and conclusions of law, do I hear a motion to approve?
Motion to approve?
Thank you, Mr. Shea. Do I hear a second?
Williamson second.
Thank you. Ms. Shirley? Mr. Shea,
Say yes.
Mr. Williamson?
Williamson, yes.
And Dryden, yes. So this variance is approved and the finding of facts and conclusions of law are approved. Thank you very much. All right, moving on to variance number 2025-00049 for property located at 610 South Church. Okay,
Miss,
all right, yes.
This one's that the applicant has asked for a continuation because we believe Mr. Williamson might have a conflict
Okay,
with this one. So they have asked for a continuance until February if you got,
okay,
if you guys agree to that.
all right, so there's a request by the property owner to postpone this variance until February. Mr. Williamson,
Yeah.
Mr. Shea,
Yes.
Ms. Shirley,
Yeah.
and Dryden, yes. So this is continued until February. Thank you very much. Thank you very much for being here. All right. All right, moving on to variance number 2025-00051. For a property located 1101 East 36th Street. I will ask the Wright Brothers Real Estate Holdings Tryon Harmon, if you are,
Yes, ma'am.
would you like to have us continue with 4 board members or would you like it postponed to 5?
Four board members is fine. Thank you.
Okay, would you spell your name for the court reporter, please?
Yes, ma'am. TYROME, last name Harmon, HAR.
Mr. Harmon has agreed to proceed with 4 members for the board for this decision. Thank you, sir. All right.
All right, this is for Bragg Brothers Real Estate Holdings, represented by Tyrone Harmon for property located at 1101 East 36th Street, owned by the applicant as well. It's seeking a variance from UDO Article 20.9 to reduce the landscape yard to be a privacy fence only. So it's essentially waiving the width of the landscape yard and the plantings and just installing a fence. Get into the details. Exhibit number 1 is a vicinity map showing the approximate location of the property. It's between the plaza on 36th Street, kind of between the plaza and North Davidson Street. Exhibit number 2 is a zoning map. It's actually zoned N1C, which is Neighborhood 1 zoning district. But as you'll see on the aerial map, it is a non-residential use and structure. And same with the abutting property to the northwest. This is a non-residential use here. And then the property to the, I guess, southeast was recently rezoned to NCCD, which is a commercial zoning district. And I think to allow a medical office to be operating in the house that's currently on that parcel.
What did you say, a medical office?
I think they're gonna rehab the house as a medical office. That's
Okay.
what was on the rezoning plan at least.
Thank you.
And this is the subject property and the existing building you see on the site here. You can also see on the aerial that there's an unopened alleyway at the back of the property here. And there's existing parking in that unopened alleyway that would be removed as part of their redevelopment or reuse of this property. This exhibit 4 is a Google Street View of the property, showing the drive here, and there's another driveway here on this side of the building. Basically, you can circle around, and parking is back here in the back. Can't really see it that well from here, but it's right past that awning, basically. The variance, again, is from UDO Article 20.9 to reduce the landscape yard to a privacy fence only. Basically, what the ordinance says is that certain uses and zoning districts require a landscape yard to provide a transition between those uses and budding zoning uses and budding uses and zoning districts, to minimize adverse impacts. And when a landscape yard is required, it's per table 20-3, it says N1C. When there's non-residential or mixed-use development in N1C zoning abutting a residential use, then you're required to install a Class B landscape yard. And then if you go to table 20-2, a Class B landscape yard is required to be 25 feet wide with 1 evergreen shrub per 3 linear feet and 1 tree for every 30 linear feet. The applicant has agreed and offered to provide a 6-foot high wood screen fence along the rear of the property line. So here's a site plan that kind of illustrates what's going on with this property. So their existing building will remain, and that comes to about here as far as where the existing building is at. These are same site plan. One is just the landscape plan and the other's the site and utility plan. They're proposing an addition. That addition I think is measured at roughly 999 square feet. And as you can see, it does not extend any further past the back of the building than currently. In fact, it's quite a bit less than the back furthest extended building. But the distance between the building and the back property line is such that there's not enough room to provide both required parking and the landscape yard. So the landscape yard would come to this area in green, which pretty much takes up the entire space. Once you include the landscape yard, there's only 11 feet between where the landscape yard would be required in the existing back of the building. So therein lies the reason for the variance request. is it's either, well, do we ask for a variance to our parking requirements so that we don't have to provide parking, or do we ask for a variance to the landscape yard? And staff recommended they pursue potentially a variance to the parking, to the landscape yard requirement, because we felt like in this area, parking on site is pretty important. There's a lot of on-street parking already that occurs, and having that on-site parking for the uses would be beneficial, more beneficial to the neighboring community. And then there's also this unopened alleyway, and the distance there is about, I think, 10 to 11 feet. So there's, once they move that back, there'll be separation between the parking and the abutting single family home that's over here. This is their, they have an accessory building back here. The house is actually more over here. I think we might be able to see it on the aerial. Well, that's a garage, and then the house is basically sitting here.
So are they taking away that driveway, or they're gonna still use that driveway,
There'll be so the driveway will be a one-way in here,
right?
and you'd circle around and exit over here.
And the alley,
They're gonna change this parking to be angled parking. That would be angled like this direction.
so the alley would still exist or no?
The alley would still exist. They just have to remove their parking from the alley because it's not their property.
Oh, okay.
So that's what's illustrated here, is this alley would remain, their improvements get removed from the alleyway to bring it into compliance with the parking requirements. And then they're asking for the variance to the landscape yard to be able to accommodate that of parking. And then they'll be committing to, as a condition of the variance, installing a wood fence here. And that we feel will screen the headlights of the cars from the residential uses to the north.
Okay.
That was exhibit 6, the applicant site plan. Exhibit 7 is the variance criteria. I'll give you all a minute to look over the findings before we dive into then all 4 standards of the variance need to be shown to be met in order to grant the variance.
When we get to it, this calls for, number 7 calls for providing a 6-foot-high wood screen fence. And that's a little bit, amorphous for me. I'm thinking we need to say solid screening.
You could, or you could say something, you could basically refer to the UDO as like a screen fence as required by the standards of the UDO, because the UDO spells out like it has to be opaque, a certain percentage opaqueness and all that.
So that's the way we should say it then,
Yeah,
refer to the
you could
UDO.
revise it to say to the, as required by the UDO.
Thank you.
Okay. I'm writing this down, John.
We can cover it too.
I
when we
know,
get to the
but
findings.
my memory is not so good this morning. I don't know what, the snow got it. Okay, you may continue.
Okay. So unnecessary hardship would result from the strict application of the regulation because Article 20.9B, the addition of the existing building triggers the requirement to install the landscape yard when one does not exist. Article 20.9, Table 20-3 requires the landscape yard to be 25 feet wide when abutting a non-residential use abuts a residential use. The abutting property to the north or rear of the site is developed with a residential use. But however, there's not a space between the rear of the building and the property line to install the landscape yard and meet the on-site parking requirements. The strict application of the regulation would require portions of the existing building to be demolished or parking and vehicular maneuvering space to be removed such that the property would not be able to meet both the landscape yard requirements and the parking standards. The hardship does result from the conditions that are peculiar to the property. The existing building on the lot is a non-residential building type constructed around 1921. And there's an existing parking area to the rear of the building. However, this location within the unopened rear alley is legally non-conforming and is required to be located on site due to the addition of the building. Basically, the addition triggers the need to bring the site into compliance with the parking standards. There's 36 feet between the rear of the building and the rear property line, and the required landscape yard is 25 feet. That would leave only 11 feet between the building and the landscape yard. And the unique placement of the building on the lot results in conditions peculiar to the property such that there is not space at the rear of the building to meet both the on-site parking requirements and the landscape yard requirements. hardship does not result from actions taken by the applicant or the property owner. The building and land were existing conditions and the applicant recently purchased the property and is renovating it and constructing an addition to the rear. The addition does not extend past the rear of the building and does not create hardship for installing the landscape yard. Hardship results from the location of the existing building and its proximity to the rear property line. According to Article 37.8A13, the act of purchasing property with knowledge that as circumstances may exist that justify the granting of variance should not be regarded as a self-created hardship. And then Exhibit 10, last one, the requested variance is consistent with the spirit, purpose, and intent of the regulations, such that public safety is secured and substantial justice is achieved. Again, that subject property was been developed with a non-residential building since 1921. The addition to the rear of the building does not extend past the existing rear building line, and the proposed addition and renovation does not change the character of that neighborhood. The existing parking at the rear of the property is legally non-conforming. And in order to comply with the ordinance, they'll remove that non-conformity. And the applicant will be moving the parking onto the site along the rear property line, resulting in the separation between the parking and abutting residential property increasing from basically 0 feet to 12 feet, which is the width of the unopened alley. The requested variance is consistent with Goal 9 and Objective 9A of the Charlotte 2040 Comprehensive Plan, which states that increased rate of restoration and adaptive reuse of existing structures originally built for commercial uses and reduce the rate of tear downs. And the comprehensive plan includes the following policy, which encourages the preservation and adaptive reuse of existing structures through strategic flexibility of development standards. And the applicant has agreed and offered to the condition to install a 6-foot-high wood fence along the rear property line, which would screen the parking from the alley and abutting residential use. Exhibit 11 is the photo of the sign on the property. And that concludes staff presentation. I'm going to go back to this one if you want to wordsmith that last bullet there.
Yes, I think that's the same wording that we need to do for number 7 too. It's,
Yeah, it's
so what we
it would
would
be
say,
number 22 in your findings is the condition.
the applicant has offered and agreed to the condition to install a 6-foot-high wood screen fence along the new property line, which will screen the parking from the alley and abutting residential use as required by the UDO? Or how would you want to word that, John?
Can we just say to install a 6-foot-high opaque wood screen fence?
I would say install a 6-foot-high wood screen fence meeting ordinance standards.
Meeting ordinance standards, okay.
Or meeting UDO standards, whichever word you want to use.
I think UDO standards would be better. All right, so the applicant has offered and agreed to the condition to install a 6-foot-high wood fence meeting UDO standards along, that should be along, not
Yep.
long. Along the rear property line, which will screen the parking from the alley and abutting residential use. Okay, so do we need to apply that the same to number 7, that same wording?
7 is not necessarily the condition, it's more describing what they're gonna install.
So 7's okay the way it is?
Y'all, I guess, on whether.
'Cause it's what they're
there.
requesting, okay. Right, so we don't need to change number 7. We changed number 22.
I would recommend that we address it in the section above the findings of fact as well. And also, since it is addressing the condition, if we could make sure that the applicant doesn't want to respond to this change.
No, ma'am.
Okay.
Okay, so so staff recommends the applicant would be providing a 6-foot-high wood screen fence meeting UDO standards. Fence meeting UDO standards.
Page, where are you referring to on the
That's under the staff recommendations.
staff? Oh, I got you.
It's on the second page,
Got you.
meeting UDO standards. Along the rear property line. Yeah, that's clarifies what staff is recommending. And then we put it in the finding of facts under number 22. clarify. Okay, all right. Do I hear a motion to approve this request as amended,
With the condition.
as with, I'm sorry, with conditions?
You taking my thunder here.
Sorry.
Motion to approve with condition.
Excellent.
I'm getting pretty good at that.
Yeah,
You are.
that's good.
Second.
Okay, thank you, Mr. Williamson. All right, Ms. Shirley?
Yes.
Yes. Mr. Shea?
Shay, yes.
Mr. Williamson?
Williamson, yes.
Dryden, yes. So we have approved the variance with condition. All right, now we need to approve the finding of facts and conclusions of law as amended. Do I hear a motion? And we amended by restating the staff recommendations, adding meeting UDO standards, and also at number 22 by adding the statement meeting UDO standards along the rear property line.
Approved
Thank you, Mr. Williamson. As amended.
as amended.
Second.
Thank you, Mr. Shea. Mr. Williamson,
Williamson, yes.
Mr. Shea,
Shay, yes.
Ms. Shirley. Dryden, yes. So we are approved with conditions. Thank you very much.
John, real quick, what's this is out of curiosity, if the owners wanted to get that alleyway abandoned, what do you do with it?
So, CDOT has a process that you can go through for right-of-way abandonment. I'm not sure if it would apply necessarily in this situation, because different alleys are handled different ways. But typically, the way that works is you would need all the property owners between wherever the abandonment would be taking place and the street, because CDOT doesn't want to have like gaps of alleyways. So the idea would be everybody that is abutting the alley could go in together and ask or work to get that alleyway abandoned. And typically, the way it works is you split it half, unless there was some other special arrangement that's made. So, 6 feet would go to the homeowners and 6
Yeah,
feet would
the
go to these property owners. In this case, they didn't want to try to pursue, it's a lengthy process and costly process because you have to get attorneys involved to do a bunch of title search and search. So they didn't want to try to pursue the alleyway abandonment for this one. And we're not even sure if CDOT would even support it either.
But back when this property was developed in 1921, the purpose of the alley I don't know what the purpose of the alley was, because it looked like pretty much there was lots of residential there. I don't know, maybe
Probably garbage.
garbage pickup or something like that, no?
It could be utilities
I-
too.
We've seen like children.
Oh, okay. Everything's
Has
over.
changed.
Yeah, okay, all right, cool. All right. Next is variance number 2025-00055. For property located at 10621 Harrisburg Road. Nicholas Custom Builders, Anthony, Mr. Rents. Is there,
I'm here, yes, ma'am.
okay, Mr. Rents, do you agree to have a decision made by the board of four?
Please proceed.
Okay, all right, so if you'll spell your name for the court reporter, please.
It's as it's spelled, Anthony. My middle name is Lot, Lott. My last name is Rentz, Rentz.
Okay, so Mr. Rents has agreed to proceed with this, with the board's decision with 4 members. Thank you, sir. All right, sir.
All right, it's the application by Nichols Custom Builders and Design Incorporated, represented by Mr. Rentz, and it's property located at 10621 Harrisburg Road, and it's also owned by the applicant Nichols Custom Builders and Design Inc. The variance is a request from Article 4.3, Table 4-6 to allow the sidewalls to be oriented parallel to the roadway frontage. The ordinance would require the sidewalls to be oriented perpendicular to the roadway frontage. So here's a vicinity map of the site, Exhibit 1. This is up near 485 on the northeast side of town, Harrisburg Road, and then the nearest cross street is Cambridge Commons. Exhibit number 2 is the zoning map. The property is actually zoned N1A. The abutting surrounding property is zoned, looks like R15 CD, and then I'm not sure if this is also R15, but it's multifamily zoning. And then across the street, you have multifamily zoning R12 MFCD as well. And then this is the roundabout at Cambridge Commons and Harrisburg Road. Exhibit 3 is a close-up aerial of the lot. Again, it's just a small little wooded lot at the corner at the roundabout. And the variance is from, again, from table 4-6, which says the sidewalls have to be perpendicular to the street. And in this case, they're asking as part of the variance for those to be oriented parallel to the street. So the original plan that they proposed was to have the building with the sidewalls oriented perpendicular to the street. But in order to do that, Charlotte Fire was going to be requiring a fire turnaround apparatus turnaround on site. And in order to install all of that driveway space for the truck turnaround, it was causing an issue for them to not be able to meet the maximum driveway width requirements, which and that section of the ordinance, which is Article 19, says that you can't have driveways exceed more than 50% of your lot width. So again, you can kind of see here, all this blue is the area that essentially would have been in pavement under the original plan. If the variance is granted and they're able to orient their sidewalls parallel to the road, then they can do a single driveway into the site and meet both the driveway requirements. Fire's reviewed this plan, fire's okay with this plan. So it meets fire's requirements and it meets the driveway requirements. It just doesn't meet the requirement to have those sidewalls oriented perpendicular to the road. This is a little bit of an odd site because this is not considered a corner lot. And it's not considered a corner lot because the multifamily development has a strip of common open space between Cambridge Commons and this parcel. So while it very much looks like a corner lot, if you're driving by, it's in technical, practical, strict application of the ordinance is not a corner lot. And so they don't have the ability to orient the building walls, whichever street is the front. If this was an actual corner lot, then they wouldn't even need a variance for this because this proposal would be compliant with the standard that the ordinance gives the flexibility when you're on a corner lot to choose which frontage you orient those sidewalls perpendicular to.
John, is that strip developable?
I don't believe it would be. It's probably,
I can't see it.
It's less than 50
this
feet.
is 82 feet here, so I would say that's measurement here says 21.58. So it's probably 30, 40 feet wide, maybe 50 at the most.
So down the road, you guys will get a variance to say, oh, well, let me build something there.
Well, they have to maintain a certain amount of common
So
open
it's
space.
probably when they developed that multifamily, it was probably part of their common open space that they used it.
Okay.
And you can
thank
see that strip here too as well.
Yeah.
Some area considerations in exhibit number 6. I mentioned the multifamily zoning across Harrisburg Road that was rezoned in 2021 175. And you can see it had some proposed building orientations that included a set of townhomes that would have been kind of perpendicular to Harrisburg, but then a set of townhomes that would be perpendicular to the extension of Cambridge Common. So with the requested variance, the orientation kind of facing Cambridge Commons is not dissimilar from what would be across the street. So when we get into the findings of facts, talk a little bit more about, the spirit and intent of the ordinance and the character of the neighborhood. It's kind of what this comes into play with.
And it didn't change the entrance onto Harrisburg Road.
No, in fact, the driveway has to be as far away from the roundabout as possible due to the CDOT's requirements for access. So they have to put the driveway in and out on this far side of the lot,
Okay, thank you.
which also played into why they laid the site out the way they did. Exhibit 7 is the standards for granting a variance. All 4 of those need to be met, and I'll give you a second to look over the findings before I dive into those.
Okay, John, you may continue.
Unnecessary hardship does result from the strict application of the regulation. As shown on the applicant's original plan exhibit, the lot is 100 feet wide and 142 feet deep. And the building cannot be oriented in accordance with the strict application of the regulation to have sidewalks perpendicular to the street, because such an orientation would require fire apparatus turnaround and result in a driveway width that exceeds the maximum allowed per Article 19.6A12, Table 19.3.1. With the variance, the applicant can rotate the building 90 degrees so that a single driveway on the left side of the site meets fire requirements, and a driveway width standards can be provided. The hardship does result from conditions that are peculiar to the property. Property is 0.42 acres, again, 100 feet by 142 feet. And access to the property is constrained by the adjacent roundabout, so that the driveway from Harrisburg Road must be on the left side of the site. The property only is the only N1A zone property on the west side of Harrisburg Road between Sam D and I-485. The abutting property to the west and south is developed with multifamily residential, and multifamily development's common open space separates the subject property from Cambridge Commons Drive. So although this property appears to be a corner lot, it only has frontage on Harrisburg Road, which limits options for building orientation. Exhibit 9, considerations. The hardship does not result from actions taken by the applicant. The applicant and the owner did not create the lot, and according to Mecklenburg County sales deed, the property is a remainder of a parcel that was created when NCDOT acquired portions of a larger parcel in 1998 for the expansion of Harrisburg Road. And the strict application of the regulation and the lot's size limit and limited frontage create the hardship. And the requested variance is consistent with the spirit, purpose, and intent of the regulations, in that public safety is secured and substantial justice is achieved. The site is surrounded by multifamily and commercial development on the west side of Harrisburg Road. The property on the east side of Harrisburg Road is zoned for multifamily development and proposes multifamily attached dwellings oriented facing a proposed extension of Cambridge Commons Drive perpendicular to Harrisburg Road. And the proposed triplex with its orientation and variance is compatible with the surrounding existing and proposed development. According to Charlotte Fire's review and email confirmation that we received from Charlotte Fire, the proposed site layout accommodates fire requirements and places the driveway away from the roundabout, supporting public safety. The proposed layout reduces impervious surface area that would otherwise be created by the additional driveways, reducing potential stormwater runoff, and granting the variance would not alter the essential character of the neighborhood. Exhibit 10 is the sign on the property, and I'll take any questions.
How many units are they planning for this?
Just 3, the triplex, because
Just a
that's
triplex?
would be allowed by right under the N1A zoning district.
All right, questions or comments from the board?
I make a motion to approve.
Thank you, Mr. Shea. Do I hear a second?
Second.
Thank you, Mr. Williamson. Ms. Shirley,
Yes.
Mr. Williamson,
Yes.
Mr. Shea,
Shay, yes.
Dryden, yes. And now to approve the finding of facts and conclusions of law, do I hear a motion to approve?
Motion to approve.
Thank you, Mr. Williamson.
Second.
Thank you, Mr. Shea. Mr. Williamson,
Yes.
Mr. Shea,
Shay, yes.
Ms. Shirley,
Yes.
Dryden, yes. So the variance has been approved. All right. All right, at this time, we're going to take a 10-minute break, and then we will reconvene. 10 minutes, please, ladies and gentlemen.
Sorry,
Yeah.
for 2025-0056 for property located at 616 Northgate Avenue. Mr. Murray, are you okay with your board members, or would you like to?
We're good to proceed. David Murray, MURRAY. Thank you.
Thank you. All right, Mr. Murray has agreed to proceed with your board members. All right, Ms. Munson, you may continue.
Thank you. Good afternoon, board. This case number is variance 2025-00056 to reduce rear setbacks. The applicant is Matt Luxak, represented by David Murray of Murray Law Firm. Property is located at 616 Northgate Avenue. The variance is from Article 4.3, Table 4-2, Road D, for setbacks for the N1B zoning of the UDO to reduce the rear setback from the required 35 feet to 30 feet, a 5-foot reduction. Exhibit 1 is a vicinity map, shows that it is close to East Woodlawn Road. It's off of Northgate Avenue. The zoning map shows that it is N1B Neighborhood 1 zoning district on Exhibit 2. Here's a Google Maps street view of the property. The variance is for setbacks of the N1B zoning to reduce the rear setback from the required 35 feet to 30 feet, a 5-foot reduction. The applicant has agreed to the condition that the variance is only applicable to the existing single-family home footprint and renovations, additions therein, and replacement if damaged or destroyed as set forth in UDO section 38.3G. Below is the table that shows the minimum rear setback, the N1B zoning to be 35 feet. Here is a survey on Exhibit 5 showing the existing home, and here is the encroachment about 5 feet. It's a non-compliant existing encroachment from the addition that was built about 2017. And the one below it, this part here, is existing legal non-conforming encroachment, the same thing, about 5 feet. Here in Exhibit 6 explains the variance criteria. All 4 must be met. Please take a moment to review. Let me know if you have any questions and want me to proceed.
So there was a permit in 2017, correct?
Correct. But the permit did not have a plot plan attached to the permit, but yes, there was a permit issued. And there was a surveying error possibly to cause the encroachment.
Okay, you may continue.
Thank you. Here are the considerations. The unnecessary hardship does result from the strict application of the regulation because of a surveying and building error during the construction of the rear setback created additional encroachment of the home and into the rear setback. There was a permit issued in 2017 for the addition to the rear of the home, but there was no plot plan attached to the permit. Strict application of the regulation would require the demolition of the encroaching addition that was built 9 years ago. The encroachment was not discovered until recently when a survey was completed for the sale of the property. The hardship does result from conditions that are peculiar to the property because the lot is square shaped and located on a corner at the intersection of Northgate Avenue and General Pershing Drive. The home is located on the lot at an angle. The rear corners of the home are encroaching 5 feet into the rear setback due to the angled placement of the home on the lot. The hardship does not result in actions taken by the applicant. The property owners purchased the property without knowledge of the nonconformity. The addition was permitted in May of 2017. The property owners purchased the home in September of 2017. Per the UDO standards for granting a variance in Article 37(8)(a)(13)(3), the act of purchasing property with knowledge that circumstances exist that may justify the granting of the variance shall not be regarded as a self-created hardship. The requested variance is consistent with the spirit, purpose, and intent of the regulation in that the public safety is secured and substantial justice is achieved. The lot is located in a residential area with single-family detached homes. The proposed variance will permit the home to meet the requirements of the ordinance and be consistent with other single-family detached homes in the area. The applicant has offered and agreed to the condition that the variance is only applicable to the existing single-family home footprint and renovations, additions therein, and replacement if damaged or destroyed, as set forth in section 38(3)(g). There are other lots nearby with similar conditions, and granting the variance would not adversely affect the adjacent or contiguous properties, and granting the variance would not alter the essential character of the neighborhood. Here is the sign posted on the property on Exhibit 9. Do you have any questions?
Questions, comments?
I'm asking a question, so I'm not understanding this one.
They want to, they're asking to reduce this rear setback line to 30 feet so that it could make this into compliance with the code.
But it's been like that for a while.
Yes, about at least 9 years for the addition. And sorry? Oh, thank you. 1953 is when the house was built. Okay, there it is.
So it's causing a problem in the neighborhood?
They're looking to sell. They were, sorry. They're looking to sell, and I believe they want to, they need to make it into compliance for the sale, the purchase.
Because the UDO changed. The regulations changed.
Oh, yes, thank you. From when it was originally built, the UDO setbacks has changed since then, so it's legally non-conforming.
Okay.
So if they weren't selling it or attempting to sell it, then they wouldn't have to apply for a variance. But because they're attempting to sell it, it has to meet the new UDO requirements for the existing setback. So
Okay.
they're just asking for a variance to drop that from 35 feet to 30 so that the corners of the house don't have to be torn down.
And the owners didn't know about this issue until the new owners did a survey. The buyers did a survey, excuse me.
Yeah,
Okay.
so there wasn't any sort of complaint from any neighbors or anything like that, and like the original house has been there since 1953. There was an addition that was done in 2017. Neither of those comply with the existing ordinance regulations. And a lot of times when folks go to buy and sell property, you know, the closings attorneys have to, make sure that they try to make sure everything is compliant with the codes. And since this wasn't in compliance with the code, the attorneys advised that they needed to get it resolved through variance or some other means to bring it into compliance. So that's why they're asking for the variance request.
Okay.
All right. Do I hear a motion to approve?
Motion to approve.
Thank you, Mr. Williamson. Do I hear a second?
I believe there's a condition.
Oh, yes, I beg your pardon. With the staff recommendation with conditions. Yes, Mr. Williamson, you should let Shay do this. And that condition is that the variance is only applicable to the existing single-family home footprint that you see on the screen right now, and that the renovations or additions that are made inside the house, but nothing that extends further outside the house, And
The way the condition is worded, it would allow them to make additions to the home, but those additions would need to meet the setback requirements, which is, so that's why it says, basically any renovations and additions. If it was just internal, we would have said renovations.
Okay.
Yeah.
so in other words, they could come back and say they wanted to fill in the little bit from the patio, as long as it stays within the 30.
Correct,
But-
as long as it stays within the 30-foot setback.
All right, so with conditions. All right, so
To approve with condition.
thank you, Mr. Williamson. All right, second,
Shay, second.
Mr. Shea, thank you very much. Ms. Shirley,
Yeah.
Mr. Williamson, Mr. Shea,
Shay, yes.
Dryden, yes. So, the variance is approved with a condition. Thank you very much. And now, we want to approve the finding of facts and conclusions of law as written with, we didn't amend anything, so with a staff recommendation. All right, do I hear a motion to approve finding of facts? Thank you, Ms. Shirley. Ms. Shirley makes a motion to approve. Do I hear a second?
Williamson, second.
Thank you, Mr. Williamson. Okay. Ms. Shirley,
Yes.
Mr. Shea? You're still reading, okay.
Shay, yes.
Okay, thank you.
Yeah.
Williamson and Dryden, yes. So the variance is approved with a condition. Very much.
Before we move on, help me understand, why is 15 in there? Number 15.
Oh, because the act of purchasing of the knowledge that serve makes, that's just that's to protect the homeowner, the new,
Shall not be regarded as a self-created.
correct.
hardship.
Yeah,
Do
so,
that all the time.
yeah, we said, so what we're saying is because when the property owner, they didn't create it, and then the buyer also didn't create it, so it's kind of one of those, it was discovered through the survey. And we put that in there.
Yeah, that's pretty standard. It's in
Standard.
I
all.
think that comes from the state statutes, right?
Mhm.
Yeah, there's legal authority that supports that, so imagine that's why it's in there.
Just seems self-evident. If it said shall be regarded as self-created hardship, that would make sense. It was not shall.
I think it's probably the state statutes probably are very specific about that because you could end up in a situation where somebody like, let's say the little lot is a postage stamp, it's not big enough to build anything on it without getting a bunch of variances. So you then go buy that piece of property. Someone could argue, well, why did you buy the property then? Why are you getting a variance when you knew that there was going to be the need for that? You created that hardship by buying the property. So I think the idea is you've given people the ability to have land transactions without holding that against them, essentially.
Thank you very much. Good clarification. All right, thank you. All right, we are now going to look at variance number 2025-00058 for property located at 2108 Belvedere Avenue. Mr. Crook, are you with us?
Yes.
All right, do you agree to have a decision rendered by a four-member board, or would you like to defer?
I agree to proceed.
All right, would you spell your name for the court reporter, please?
K-E-V-I-N, Crook, C-R-O-O-K.
Okay, Mr. Crook has agreed to have this four-member board approve or deny this variance. All right. You may continue, Ms. Monsegur.
Thank you. This case number variance 2025-00058 is to reduce the corner side setback and an accessory structure in the established setback. Alex Heroy is the applicant represented by Kevin Crook of B&B Pools for property located at 2108 Belvedere Avenue. The variance is from Article 4.3, Table 4-2, Row B for setbacks for N1C zoning of the UDO to reduce the corner side setback from the required setback of 10 feet to 5 feet, a 5-foot reduction. The second variance is to Article 17(1)(E)(1) to construct a pool in the established corner side setback. And Exhibit 1 shows a vicinity map. It is off of Belvedere Avenue in the Midwood area. The zoning is N1C Neighborhood 1 zoning districts. It is on the corner of Belvedere Avenue and Midwood Place. Here's a close-up of the aerial map on Exhibit 3.
Can you go back to that aerial just a second? Where is it they want the variance? At the back of the house or the side of the house?
Corner
Here?
side setback.
Okay. thank you.
Yeah, we'll be able to show you
Okay,
more.
Thank you.
Yes. And so there was 2 variance requests, one to reduce the corner side setback of 10 feet to 5 feet. And the second variance is to construct a pool in the established corner side setback. There is a condition that the applicant agreed to that the variances are only applicable to the proposed accessory swimming pool, and that screening will be provided between the pool and street intersection. Here's the part of the code on table 4-2 that shows the N1C zoning setback for the corner side setback is 10 feet. And the part of the code that says that it's the accessory structure, no accessory structure is permitted in the front or corner side setback.
I'm sorry. Can you read that again, please?
Yes. Come on, go away. So it says no accessory structure is permitted in the established front or corner side setback along a street or frontage.
Front or corner. Front or corner.
Front or corner side
Pools
setback.
are uniforms. You can put them pretty much anywhere in your property, but corner or front is off limits.
Yeah, and we have the definitions of established setback up at the top of the findings. Established setback is basically the area between the curb line, lot line, or other points set by the ordinance and the building line of the or of the building and structure. So basically anything between the building and the street is considered the established setback.
And I kind of went, I just pushed to this slide, but it shows the established corner side setback area, the established front setback. So here's your site plan. Here's the 10-foot corner side setback line, and here's the proposed pool area. They're requesting to reduce it by 5 feet instead of 10. And here's the corner side setback line on the concept plan and Exhibit 6. And here.
No, wait.
Mhm.
Go ahead.
The application talked a lot about heritage trees. Is that gonna show up here in this? On your?
No, I don't have where there's heritage. Well, there's some here.
One where the pool's going. And if they don't put it there, then you lose more heritage trees on other parts of the property. Is that sound right?
Yeah, that's part of the findings of facts. Let's take a look.
Yeah, it's number 14. Says locating the proposed pool further away from Midwood Place would increase potential damage to existing heritage trees on the eastern portion of the lot.
Yes, I just.
Locating the pool farther away from Midwood Place would place the pool more to the side of the home toward the street intersection rather than the rear of the home.
So we're looking north right now, this slot.
Trees, yeah. Okay.
So.
What's the question?
On this, looking at this here, are we looking north or is it?
North would be kind of the,
But yeah, north is kind of an angle heading up towards Belvedere.
this is rotated upside down, so bottom of the page would be more north.
East is the corner.
East is the
What I'm asking,
corner.
east is the corner.
Yes, east would be almost near the intersection of where Belvedere and Midwood Place come together.
Okay.
And when you look at this area where we're talking about those trees, so if, for example, if they put it in the front, that's where there's, where we'd say we would lose those trees.
There, the applicant's presentation has a street view image that shows the trees better. We could pull that up and show the board. as
Sure.
well.
Yes, thank you. Hmm. I didn't get anything.
If Alex would have emailed it to you, I guess. Did you? You should have gotten it in your email. See if I can pull it. This is the picture. I can just. Yeah, if you want to pass it.
Well, we need,
You don't need over. I mean,
I don't understand.
Just have the full, you know, we'd have to square you in.
did he email it to me?
I can check. But
So.
Let me get it back to you.
One day at 4:41. So.
You said Monday. Put it in there.
Grass. Well, I think the board is got a grasp on where it could go. And what would be in its way if we went in any of those places. That's kind of where I'm coming from.
And
Yeah.
we're gonna get
Well,
you the street view.
basically, if you go back to if you envision the slide that showed where the established front and corner side setbacks are, the only place that they could locate it without having to get a variance from that section in 17 is to the left side of. Can you go back to real quick, can you go back to that slide? The one that shows the established setbacks?
Yes.
So the only place on the property where they could locate the pool and not have to get a variance from any of our standards would be to that space that's on the left side of the house. And there's not really enough room over there, and there's trees over there as well. And you'd have I think there's a 5-foot side setback that applies over there. So you'd have to stay out of the 5-foot side setback. So the way we were looking at it is, yeah, there's some heritage trees on the property, but you're going to need a variance regardless of where you put it on the property, because of the requirements that it has to be out of the established corner and side or front and corner side setbacks.
We had a dime for every corner of the lot, and we come before this board, we all. Well,
This one is more unique than others that we've seen because of how sharply the angle is. Normally folks would have, this property doesn't even have a rear yard. So there's no really a rear setback at all here. So, you know, typically a pool like this would be either to the side of the house or in the rear. And in this case, both of those locations, putting it more to the side, that's still in the established corner side setback, and putting it more to the rear of the house is still in the established corner side setback.
so staff, they're comfortable that where it's located.
Yes.
You're, gonna ask you this question, so seriously, it seems possible to move that pool 5 feet closer to the house.
Currently, they're showing 10 feet between the pool and the proposed covered porch. So it may be possible to move it closer. I mean, I guess that's something that you all could ask the applicants more about in terms of exactly why, you know, they want it exactly where they plan to put it. But that's what they're showing. They're showing a 10-foot distance between the pool and the edge of that covered porch, right there where the cursor is.
To be constructed.
Correct. The covered porch is proposed. But there's no requirements for covered porches being outside of established corner side setbacks, so you can, the covered porch basically is a by right add-on to the house.
Is there anything that I was just gonna show you the images that the applicant provided us? Proposed pool placements? The view outside the fence? Mhm.
Crystal, what was your last exhibit? Because if you're gonna show this, we have to give it an exhibit number.
That's not our presentation. That was the
Yeah.
presentation
No, I
from. the
know, but
applicant.
if we're gonna show it as part of the presentation, we'll need to give it a government exhibit number.
So if you go back to our slides. That's exhibit 5, so we can make the applicant's pictures exhibit 6, I guess, and then we just need to adjust the exhibit numbers for all of our other slides for this presentation,
could
or
just
do we
make
add
it
it at
a-
the end?
what's your exhibit?
Just go to the last one and
Okay.
then we'll,
Go to the picture of the property. then.
so we're with the sign.
With the sign, okay.
And then, so we're gonna say this,
Exhibit 13.
it'll be
then.
exhibit 13. We will add it and update that.
There's already some kind of porch on the back on the house where they're gonna build the side of the house, they're gonna build a pool. Correct, based on features that.
Go back to that slide.
Go back to the applicant.
One more.
The applicant said. The applicant picture.
Our exhibit, our new.
Applicant
exhibits.
pictures?
It looks.
There's a screened in porch. Are you adding one?
No, the house.
Oh, okay. Never mind. I thought the covered porch was being added on. Sorry, that's our mistake.
It's existing.
There's an existing, yeah, it's an existing covered porch as you see in the photos here. Yeah, sorry, I thought, I saw on the plan that we thought that it had been labeled as proposed porch.
The safety issue of walking needs this amount of space.
10 feet is from the edge of this to the edge of the pool, basically.
Yeah, we have to have
Okay.
enough. So, cause
Right.
he asked about if we could move the pool over and then you don't have a walkway around the house instead of.
We have to be at least 5 feet off the foundation with our pool, so we don't cross the property, the plane of the footing.
Okay, got it. So, to address the question as to why can't they shift the pool closer to the house? I guess there's some requirements for maintaining separation between the foundation and where you'd be digging out for the pool. So there's that to account for, and then they need space for a walkway between the edge of, if you go back to the picture of the porch, Crystal,
Okay.
the rear of the house. Here, keep going.
Fine.
So in that picture there, so where those stepping stones are, that's essentially where that 10 feet of walking space would be.
For the record. Is that what we've labeled government exhibit 13?
Yes, on government exhibit 13, the proposed pool placement slide shows some stepping stones between the screened in porch and the area where the pool would be located, and that's where that 10 feet of space for the basically walkway and clearance from the foundation would be located. Yeah, the pool is essentially where the pool would be essentially located where those timbers are here. So this area that's kind of like seating and garden space, that's where the pool would be proposed to be located. And they can't move it closer to the house because of the requirements, you don't want to dig right up to the foundation for digging into the pool. And then also you need space for walking around the pool.
So that tree is showing, and then that's the tree that's going, the only tree that they're gonna be moving,
There is one tree that would be removed per the applicant's plans, and the ordinance allows you to remove it, but you have to pay a mitigation fee, and they would be responsible for paying that mitigation fee for that tree removal. I don't know if it's that specific tree that's shown, but there is a tree somewhere in the area that would be disturbed.
We're on the same page as staff. You guys look at this, there's no rear yard, right? So look at the side yard. And the side yard was not big enough because, can you go back that slide, Crystal, when you had the purple? There you go. So all space enough. Line.
Should measure that.
Side.
Whole thing. It's still not really established setbacks. And even if you put it up here. You still would have to get a variance, because it's not really setback.
So because David is. Because this is a through lot, that's why that, because what's happening is. Chris, will you show him the side again? So that's, that would be a side yard, 5, as John's mentioned, 5 feet from there, because this pinches down into a triangle. That would be a through. Belvedere as a front, we're saying it's front, and then. While Midwood, I'm sorry. Is also gonna be an established corner side. And so that's the issue so wherever they put it, they're gonna need a variance. And so when we were speaking with the applicant, John and Crystal, it was determined that where they're having it, that was probably the least most intrinsic, because as you get closer to that intersection, now you're getting more traffic, things like that. So.
Thank you. All right.
Thank you. We are in Exhibit 8, where it shows the standards for granting a variance. All 4 need to be met. If you'd like to look over your findings of facts.
Is there anyone in opposition?
There's no one here in opposition.
Thank you. Okay. All right, Crystal, you may continue.
Thank you. We are at Exhibit 9, the considerations. So unnecessary hardship would result from the strict application of the regulations because of the odd shape of the lot, required setback locations, placement of the existing home, and location of established setbacks. The lot is a triangular shape located on a corner of Belvedere Avenue and Midwood Place. Belvedere Avenue is the shorter street front and is where the required and established front setbacks are located. Midwood Place is the longer street, creating a 10-foot corner side setback and an established corner side setback along the entire street frontage. The angle of the intersection is extreme, and the placement of the house on the property away from the intersection is such that the majority of the lot is within the established front and corner side setback. Strict application of the regulation does not allow accessory structures to be placed in the established corner side setback, and there is not space to the rear or left of the home to place the proposed pool. The hardship does not result from conditions that are peculiar to the property because the angle of the intersection is extreme and the placement of the house on the property away from the intersection is such that the majority of the lot is within the established front and corner side setback. The existing home is oriented facing towards Belvedere Avenue. The property essentially does not have a backyard where pools would be typically located. Locating the proposed pool further away from Midwood Place would increase potential damage to existing heritage trees on the eastern portion of the lots. Locating the pool further away from Midwood Place would place the pool more to the side of the home toward the street intersection rather than the rear of the home. The hardship does not result from actions taken by the applicant. The unique shape of the lot and placement of the home built in 1941 was not due to the actions of the applicant. Per the UDO standards for granting a variance in Article 37(8)A 13(3), the act of purchasing property with knowledge that circumstances exist that may justify the granting of a variance shall not be regarded as a self-created hardship. Lastly, the requested variance is consistent with the spirit, purpose, and intent of the regulation in that public safety is secured and substantial justice is achieved. Construction of the pool to be located within the established corner side setback, 5 feet from the corner side lot line, aligns with the essential character of the neighborhood by allowing the applicant to place the pool closer to the rear of the home. The applicant has offered and agreed to the condition that the variance is only applicable to the proposed accessory swimming pool, and that screening will be provided between the pool and street intersection. Here is the sign posted on the home on Exhibit 12.
Okay, so where are they putting the screening? Can we just go back maybe to that one?
Right here, because it shows the screening.
And what is the screening? Do we know? Shrubbery?
Checking to see if I have any notes on that.
Down here in the pool or something. I would just say it doesn't, the plans don't specify, but the illustrate shrubs.
Thank you. Yes, the plan doesn't specify what type of greenery, but it appears to be shrubs.
All right, is that vague enough to be specific enough to make sure that there's some screening there?
Well, they're gonna have a noise issue, so it'll behoove them to do something pretty strong there to buffer that pool.
That's a pretty quiet street.
Yeah.
Yeah, we didn't want to specify like screening per ordinance standards like we have done on other cases because the screening isn't a requirement of the type of use that it is. You're not required to screen your pool from adjacent uses and that kind of thing. But in the interest of, privacy for the applicants and then also just screening from the street, we suggested that they provide some sort of screening, which is why the condition is in there. They don't know exactly what that's going to look like yet, because they haven't, determined these species and that sort of thing. But they are planning to provide screening to Mr. Shea's point, for their own privacy. So
You're okay leaving it?
And you have specified between the pool and the street.
yeah,
And the pool and the intersection, so that takes care
yeah,
of
the
it.
L shape, and that's what our main concern would be just to screen it from the visibility of any pedestrians that would be walking down the two streets.
Okay, thank you very much.
They'd still have to put a fence in there.
I believe building code requires a fence of some sort around pool,
So,
yeah.
yeah.
And there's an existing fence. I'm not sure I think they're planning on maintaining the fence that's along the back of the sidewalk. So that's already existing and you can see that in the applicant's exhibit 13 slides.
We get fence or something. All right.
It's gonna be four
All right.
feet, I think.
Yeah. Any other questions or comments? There it is.
That won't be code though. Yeah, no. Not our gig.
Oh, okay. Do I hear a motion to approve the variance or disapprove?
I make a motion to approve with condition 21.
So technically,
I make a motion to approve with condition.
thank you.
Thank you, Mr. King. Do I hear a second?
Williamson second.
Thank you, Williamson. All right, Ms. Shirley? Yeah. Mr. Williamson?
Williamson, yes.
Mr. Shea?
Jay, yes.
Dryden, yes. All right, now, the finding of facts and conclusions of law.
I'm gonna steal Deborah's thunder. Number 15, can we change further to farther, please?
Yes,
Thank you.
farther.
Farther. Measure of distance, farther.
Thank you very much. All right, do I hear a motion to approve with amendments.
Correct.
Motion to approve with amendments.
Thank you, Mr. Williamson. Do I hear a second?
Shay second.
Thank you, Mr. Shea. All right, Ms. Shirley,
Yes.
Mr. Williamson,
Yes.
Mr. Shea,
Shay, yes.
and Dryden, yes. So the variance is approved with conditions, and the conclusions of law and finding of facts are approved with amendments. Okay. Thank you very much. Okay, board, we need to approve. There's been a request for 3 agenda items to be moved to the February meeting. Variance number 2025-00044 for property located at 110 Honeywood Avenue. Variance number 2025-00050 for property located at 620 Queens Road. And then variance number 2025-00057 for property located at 2830 Huntingtown Farms Lane.
Flush.
So if we could approve those 3 requests for deferral. Do I hear a motion?
Motion to approve.
Thank you, Mr. Shea. Do I hear a second?
Second.
Thank you, Mr. Williamson. Ms. Shirley?
Before- Sorry, before we vote, do we have to do number,
No, because we've already approved that
already
one.
been approved? That doesn't have to be.
Yeah, we already did know the
Okay.
2025-0049, we approved and continued at the request of the
Okay.
applicant. Okay, so Mr. Shea has made a motion to approve these 3 variances being deferred to February. Mr. Williamson has seconded. Ms. Shirley?
Yes.
Mr. Shea?
Shay, yes.
Wait, Mr. Williamson?
Williamson, yes.
Dryden, yes. All right, our final act today, board, is to approve the minutes from our November 18th meeting. I didn't see any,
I never saw the things.
oh, she has yours. Remember that.
Make a motion to approve.
Thank you, Mr. Shea. Motion to approve. Do I hear a second?
Second.
Thank you, Mr. Williamson. Ms. Shirley?
Yes.
Mr. Shea?
Shay, yes.
Mr. Williamson?
Williamson, yes.
Dryden, yes. So the minutes from the November 18th board meeting are approved. Thank you very much. This concludes,
One more thing.
I'm sorry, one more thing, Mr. Fortune.
Just giving you guys as the board heads up, I mean, we're just making one request to staff. Just make sure that when Kamisha sends you like the meeting request and the meeting dates, that we can just confirm, because what happens is when we miss, like, because we had to cancel December's meeting,
Right.
we get long agendas, and like right now, like February's agenda right now, just roughly on our cases, we have 11 cases. That's estimating. We think it might be, and then 2 of them might be appeals. So also with the timing, just remember, hey, we go from 9 to it's like supposed to be like 9 to 3. So just make sure, because again, we know life happens, we can help out, but it's just like, hey, to have the full board here, because again, if someone does have a conflict or if someone is sick, we just need to be able to do that. And then that way it doesn't look like staff just missed, because sometimes when people ask us that we have applicants, especially if someone was waiting to sell a home or something like that, and then they're now waiting another 30 days. And it's just those things. And again, and I know things happen in the holidays. Just like, hey, if you're on vacation and we send that date, just let us know, because then that way we can set that meeting up. Because like, for example, like today, the weather, if we'd had the meeting in December, we might have been able just to say, let's just cancel this meeting. But because staff was going on Friday, we were trying to go through this whole rigmarole. What happened if the city was shut down today and we'd have to get in here, and then it's pushing you guys and as professionals.
Well, that said, on behalf of the board, I want to apologize to you guys.
No, don't, Kevin, you're good.
I know I was part of the problem here, and believe me, I feel tremendous responsibility to serve the city. And it was dropped on me. It was a very important thing. It was dropped on me. I really thought we were in the clear because everyone knew we were all hands on deck. And I made Kamisha work extra overtime. I apologize for that.
So I don't want to say it was anybody, and we appreciate that, sir. So it's not, I don't want to sit here and say it's like any individual. It's just to make sure, because what happens is someone, I know what staff has been doing. We've been trying to limit the cases you guys get, and we've been getting out of meetings we're starting at 9:30. We're getting out at 11:30. Well, what happens is I don't want someone thinking, hey, I schedule a meeting at work at 1, and then all of a sudden we are going till 2, 3, 4 o'clock. And then ultimately, for example, if we do know we're going to go down board members, then we as staff need to rearrange the cases that are like controversial. We want 5 here, because again, when you get to like some of the recommendation where it's like, hey, we can go with 4, because most of the time, most applicants are like, as long as there's no opposition. But for example, if you guys started asking questions, if we think it was going to go for a denial, then we're going to want to say, hey, let's just go ahead and continue this to the next meeting. So that way we're not putting that property owner in that applicant. So, but that's it. So again, I do appreciate.
I do appreciate you letting us know, though, that next week it's going to be a longer day so that we can, well, not for me, because I don't have any appointments after this, but to let people know that, yes, you would need to allocate the whole day if you can.
And also and as part of our duty as staff, we do try to talk to applicants. So like some of the appeals ones, we're going to talk to them to say, hey, do you really want to do this? And if they say yes, then obviously we got to go there. But obviously, as you know, for example, as I say, if you sit down and think about it, if an appeal, staff is probably going to take 20 minutes. The applicant's going to take 20 minutes. So as you can see already, with 0 questions, we're almost at an hour already before you guys. And then ultimately, I would assume you guys are going to have questions just because things are going to get said. And then ultimately, like I said, and also for us right now, lately, we have not gotten a lot of opposition from anybody on our cases. So a lot of it's been able to be put on the recommendation. But if someone does walk in and says, I'm opposed, again, that's a 30-minute, as I like to say, that's a minimum of 30-minute case just on both sides presenting and with all 3 of us. So, like I said, thank you for your service. So again, it's not because we know it takes a lot of time, trust me, for staff and for you guys. So we appreciate that. But it's like I said, we just want to make sure so that way we can keep your guys's schedule down too, and ours and ours and our calendar.
We appreciate what staff does. So thank you.
Thank you very much. Okay.
Thank you. And that's all I have. So
All right.
There's box lunches again, if you haven't got one, grab you a lunch. And then if you've got parking that you need validated,
Tickets.
see Kamisha for that.
Can we officially adjourn?
Yes, we are officially adjourned. Yes.
Thank you so much.
Sorry.
No worries.